In this video, we will discuss about the case of IC Golaknath and others versus State of Punjab and another. So this case is of the year 1967, and if we have a look at the questions which will be clear from this case, then mainly there are two questions. First is, can the Parliament of India amend the fundamental rights of Indian citizens? And the second one is a constitutional amendment under Article 368 of the Constitution and ordinary law. Now, some introduction about this case. So firstly, IC Golaknath versus State of Punjab is an important judgment of the Supreme Court which dealt with the amending power of the Parliament with respect to the fundamental rights conferred under Part 3 of Constitution. Now, in this case, IC Golaknath was the petitioner and the State of Punjab was the respondent. Okay, so now let's have a look at some brief background about this case. So in 1953, the then Punjab state government enacted Punjab Security of Land Tenures Act of 1953, and this act was placed under the 9th schedule of the Constitution of India by the 17th Constitutional Amendment Act of 1964. Now, what is the 9th schedule and what is its significance? So mainly when we talk about the schedules of the Indian Constitution, then the 9th schedule has been one of the controversial ones, because in this schedule there are a list of laws that cannot be challenged in courts. And something interesting about this is that out of 284 such laws which are shielded from judicial review, and in that 90% of laws are about agriculture and landholding. So as we read that the Punjab Security of Land Tenures Act of 1953 was placed under the 9th schedule. So what does it mean? That it cannot be challenged in courts, right? Now, Golaknath family in Punjab had over 500 acres of land, and exercising its authority under the Punjab Security of Land Tenures Act of 1953, the state government informed Golaknath that he can possess only 30 acres of land and the rest will be treated as surplus. So at that time, the right to hold and acquire property was a fundamental right under Article 19 Clause 1F. Now, Golaknath filed a writ petition under Article 32 of the Constitution, which is also the heart of the Constitution, that is Article 32, and challenged the validity of the Punjab Security of Land Tenures Act. Further, he contended that the said Act violated his fundamental right to hold and acquire the property. Now, this was background of the case. Further, what are the legal issues involved? The case involved two important legal issues. First one, as I told you, whether the Parliament by law can amend the fundamental rights or not, and whether such an amendment is a law under Article 13, Clause 2 of the Constitution. Now let's have a look at the arguments. So the main contention of the petitioner, that is Golaknath, was that the fundamental rights provided under Part 3 of the Constitution of India are the essential and integral part of the Constitution. They cannot be taken away by any act of Parliament, and the Constitution without the fundamental rights is like a body without a soul. So he contended that the Constitution drafted by the Constituent Assembly is of permanent nature. So any act which changes or tries to bring about a change is constitutional. The amendment cannot bring in new ideas into the Constitution. Any changes, if made, should be in accordance with the basic idea of the Constitution. He further contended that Article 368 merely prescribes the procedure for amending the Constitution, and it does not confer any power or authority on the Parliament to amend the Constitution. Golaknath argued that any law under Article 13, Clause 3A includes both statutory and constitutional. Therefore, any law which violates the fundamental right conferred under Part 3 is unconstitutional. So this was the main theme of this case, that any law which violates the fundamental rights conferred under Part 3 is unconstitutional. So the state of Punjab responded by saying that the power to amend the Constitution is an exercise of sovereign power. It is different from legislative power of the Parliament. The argument of the state of Punjab was based on the reason that changing needs of society require changes in the constitution. Otherwise, the constitution would become too rigid. So the state further argued that all provisions of the constitution are of equal status and equal importance. There is no special status to the fundamental rights under Part 3. So these were the arguments put forward by both the parties, and now we will have a look at the judgment. So prior to Golaknath case, Supreme Court in Shankari Prasad versus Union of India of 1951 and Sajjan Singh versus State of Rajasthan of 1965 held that no part of our constitutional was unamendable. Right. Now Parliament, by passing a Constitutional Amendment Act under Article 368, can amend any provision of the Constitution, including the fundamental rights and Article 368 itself. It was held that the law under Article 13 referred to ordinary legislation made by the Parliament as a legislative body and would not include any amendment of the Constitution which was passed by the Parliament in its constituent capacity. So basically what it means is that the term law which is under Article 13, it is referred to as any ordinary legislation made by the Parliament as a legislative body, and it will not include an amendment of the Constitution which was passed by the Parliament in its constituent capacity. Now, in Golaknath case, Supreme Court overruled this position and held that fundamental rights provided under Part 3 of the Constitution cannot be subjected to the process of amendment provided in Article 368. If any of such rights provided under Part 3 is to be amended, a new Constituent Assembly must be convened for making a new constitution or radically changing it. So, the ruling of the Supreme Court was based on the view that power to amend the Constitution was also a legislative power conferred by Article 245 by the Constitution, so that a Constitution Amendment Act was also a law within the purview of Article 13 Clause 2. So what we understand is that fundamental rights which are provided under Part 3 of the Constitution cannot be subjected to the process of amendment, means they cannot be amended with the help of the provisions which are provided in Article 368, and Article 368 provides for the process of the constitutional amendment, and it is under Part 20 of the Constitution. Also, what is being said is that if a new Constituent Assembly can be formed, only then they can make a new constitution or radically change it, and then only Part 3 is to be amended. So basically, Supreme Court has rejected the idea of amending the fundamental rights of the Constitution. And now, since 1950, Parliament, by invoking the power under Article 368, passed numerous legislations which violated the fundamental rights. Therefore, to check the colorable exercise of power and save the Constitution from autocratic actions of the Parliament, Supreme Court held that the Parliament cannot amend fundamental rights. Supreme Court held that the fundamental rights are the primordial rights necessary for the development of human personality, and the judgment provided for the prospective overruling of the law. And here, prospective overruling of the law implies that the effects of the law to be laid down will be applicable on future dates only, that is, all the past decisions which were taken will not be affected by this decision. So what was the impact? The Parliament tried to supersede the Golaknath case ruling by amending Article 368 itself, and Parliament passed the Constitutional Amendment Act of 1971. It was the 24th Amendment, and according to it, an amendment of the Constitution passed under Article 368 will not be considered as law under the meaning of Article 13. It further stated that the validity of an amendment to the Constitution shall not be challenged on the ground that it takes away or affects the fundamental rights. So basically what we infer from this case is that the Parliament cannot amend the fundamental rights, and the judgment provided for the prospective overruling of the law. Right. Now, 44th Amendment eliminated the right to acquire, hold and dispose of property as a fundamental right and made it a legal right under Article 300A. So this was about the right to property which was repealed, and now it is only a legal right in India. Further, one last thing to be noted is that any amendment of the constitution passed under Article 368 will not be considered as law, and this law term has been included under Article 13. So here, as you can see, the Article 13 of the Indian Constitution, and here the term law has been mentioned. So the laws inconsistent with or in derogation of the fundamental rights, and here any particular constitutional amendment under Article 368 will not be considered as law under this article. So this was the basic thing which we need to understand from this case, and this is it about this video, and thank you so much for watching.